I think we now have about 66 people that have joined us. Good morning, everyone. Good afternoon, good evening, depending on where you are joining us from. Thank you very much for taking your time to participate in this webinar on privacy and data protection in Africa, which is a very important discussion. It is part of the Center for Human Rights talks on COVID-19. We are having these talks every week on Tuesdays and on Thursdays, and we tackle different thematic areas in the context of COVID-19. We have had the talks on the rights of women. We have had on police brutality, on children, so quite a number of them. So this is just one of those, it's part of that series that is going on. And this is the beginning on the right to privacy. We are going to have another one on the 7th of July, still on the right to privacy. So just to say that this webinar is being held in English and in French. So at the bottom of your screen, that should be on your right, there is an icon for interpretation there. So please kindly click on that icon and choose your language option, English or French. At the bottom of your screen, on your right, choose the language that you prefer, English or French. And also, just to remind you to keep your microphone and video muted throughout, and then we'll allow the speakers at least to remain with their videos on, but everybody else keep it muted. Thank you for your cooperation. And we'll also ask you to participate in a poll that will be shown. It will pop up on the screen. So please participate. That is information that will help us with our upcoming webinar or future plans on the issue of the right to privacy and data protection that we are running with. So to introduce our speakers, we have from South Africa, we have Advocate Pansy Tlakula. She's the chairperson of the Information Regulator in South Africa. And some of you would recall that Advocate Tlakula was chairperson of the African Commission on Human and People's Rights. And during her tenure, she was also the Special Rapporteur on Freedom of Expression and Access to Information in Africa. Welcome, Advocate. We also have from Kenya.
Thank you.
We have Commissioner Lucy Ndungu. She is part of the Commission on Administrative Justice in Kenya. So welcome, Madam Lucy.
Thank you.
From Senegal, we have Professor Mamoudou Niaye. I hope I'm pronouncing that well. He is part of the Data Protection Authority of Senegal. Those are our speakers. We were supposed to have Madame Marguerite from Burkina Faso, but due to some circumstances, she's no longer able to join us. So thank you very much to our speakers. And also just to note that these are members of the African Network of Data Protection Authorities in Africa. So what we are having today, we want to hear from those that have been entrusted with the mandate of implementing the laws on data protection on the continent. So hence you see that our speakers are coming from that particular network. So thank you very much, our esteemed speakers for joining us. And thank you very much to our participants. You're joining us from Africa. I've seen in the registrations, we have speakers from Southern Africa, East Africa, West Africa, North Africa, and beyond the continent. Thank you very much. So what we're going to do, we'll start off from a general level where we are looking at country-specific situations, and in Africa, in general, the laws that are available and the laws that have been enacted in our different country contexts, and then we'll move on to COVID-19 specifically. So when we look at the African, and when we look at the right to privacy, it's enshrined in our human rights instruments, on our ICCPR, our UEDHR, and also if we look at our constitutions themselves, we find the right to privacy enshrined in our constitutions. But looking at the continent itself, the continental framework, if you're looking at the African Charter, it doesn't have the right to privacy. So at least at the African Commission on Women and People's Rights, the mandate of the Special Rapporteur led a process of the revision of the Declaration on Principles of Freedom of Expression. And when you look at this new declaration, Principles 40 to 42, they have provisions or principles that speak to privacy, at least to the extent that they are applicable to freedom of expression and access to information in Africa. At sub-regional level, we have the model law on data protection, the SADC one, and then we have the ECOWAS Supplementary Act on data protection. In East Africa, we have a framework of cyber laws. And then we have the Continental Convention on Cybersecurity and Personal Data Protection. So before we delve into the subject of today, I would like to ask Advocate Tlakula to briefly tell us about the network of data protection authorities, what it is about, what is its mandate, what has it done, if there are any achievements, notable achievements. There are stakeholders who might be participating here who would like to know about this network and possibly engage with the network. Advocate, to you.
Thank you very much and good morning to everybody. Hlengiwe, I know that our chairperson was supposed to be here to talk about the network. If you don't mind, I'm going to request you to ask Professor Mamadou to talk about the network because Commissioner Awa from Senegal has been a member of the network and she's also in the executive longer than me. So can I, with your permission, defer to Professor Mamadou on this topic?
That's fine, that's fine. Over to you, Professor Mamadou. If you can tell us about the network.
Merci. Je profite de la prise de parole pour remercier les invités et tous les participants, particulièrement l'honorable Madame Pansy, et tous les autres membres du réseau. Le réseau est né d'une rencontre ici au Sénégal en 2014, une rencontre africaine de toutes les autorités de protection des données. Donc, cette idée de réunir les réseaux et d'en faire une association afin de promouvoir la protection des données personnelles en Afrique a fait son chemin et au gré des contributions, les statuts du réseau ont été adoptés au Burkina Faso en 2014, donc en 2016 plutôt. Donc, officiellement, le réseau est né en 2016. Et ces statuts ont été amendés plus récemment en 2018 au Maroc. Dans sa configuration actuelle, le réseau est une association internationale de droit marocain parce que le siège est fixé au Maroc où est le secrétariat permanent et le réseau est dirigé par un bureau composé d'un président et de 2 vice-présidents. Dans sa version actuelle, le réseau est dirigé par l'autorité du Burkina Faso qui est assisté de 2 vice-présidents, l'autorité du Ghana et l'autorité du Cap-Vert. Le secrétariat permanent est assuré par le Maroc. Le réseau a un statut qui fixe ses missions, son mandat et qui donne les éléments pour devenir membre du réseau. Et le réseau est doté depuis cette année 2020 d'un plan d'action sur 2 ans. Le plan d'action a été adopté lors de la dernière rencontre du réseau en ligne, une rencontre en ligne. Et actuellement, le réseau collabore avec l'Union africaine, le réseau collabore avec l'Alliance Smart Africa, le réseau aussi collabore avec des institutions internationales comme l'Association des autorités francophones et comme le Conseil de l'Europe dans le cadre de la Convention 108. Donc voilà de manière assez brève une présentation sommaire du réseau et au fil des discussions, je pourrai revenir sur certains éléments. Le réseau est composé actuellement d'environ 15 membres qui sont issus des différentes langues qui sont utilisées en Afrique. Donc, il y a des membres qui viennent du groupe francophone, du groupe anglophone, du groupe arabophone et du groupe lusophone. Donc, le réseau est un échantillon assez dense de toutes les sensibilités qui existent en Afrique. Et l'une des principales missions du réseau, c'est justement d'aboutir à une harmonisation des législations, à un échange des meilleures pratiques entre les autorités et renforcer la protection de la vie privée et des données à caractère personnel en Afrique. Donc, je remercie la présidente Pansy de m'avoir permis de présenter brièvement le réseau. Et au cours des discussions, je pourrai revenir sur certains éléments. Je vous remercie.
Okay, thank you very much for that on the network. At least we now know that there's a network in Africa of data protection authorities that we can engage on these issues. I would move to, I'm going to move to Commissioner Lucy. Commissioner Lucy, please address us on the situation in Kenya. We are aware that Kenya adopted a data protection law in November last year. And kindly tell us about this law. What are the highlights, just the snippets? What are the highlights? What is happening at the moment in terms of implementation, in terms of putting in place an office for data protection, for the Data Protection Commission, and also what has been happening since the commencement date? Commissioner Lucy.
Thank you, Chair. Thank you, everyone. As I said, I'm Lucy from Kenya. I am currently Access to Information Commissioner under CAJ, and we are not connected to the data protection law. It was established under the Ministry of Information, but I am aware that the Act came into operation, and soon after, the Ministry of Information did advertise for a data commissioner, and they closed the advert some time ago, but due to COVID and its implication, that has not been finalized. I am also aware that the regulations in certain sections of the law were also drafted, and they were forwarded to the relevant section of the committee in Parliament, and they are ongoing, but due to COVID, they also delayed. I am also aware that we hope to have the implementation of the Act as soon as it's practicable in the Ministry of Information. What are the highlights? We do know that data...
Personal Information Act.
Hello?
2013. And as of a few days ago, there is now a commencement date that that we've been waiting for. So my question to you, Advocate, what has been happening till now, up to this pronouncement of the commencement date? The work of the information regulator, and now that there is a commencement date, what does that mean? What does that mean for the information regulator? What does that mean for us? What does that mean for members of the public? What should we then be doing? Take us through that process. And also the other thing, seeing that this law predates the General Data Protection Regulation, has the information regulator reviewed the provisions of this law? Is it still fit for purpose? Is there need for it to be amended or reviewed? Over to you, Advocate.
So many questions, but I want to say that perhaps I'm not the right person to answer some of those questions, because you know the Act is domiciled under the Ministry of Information. And my proposal is that next time we'll hold such a meeting, we'll bring on board the Ministry of Information, and more specifically, the permanent secretary in that ministry, who is supposed to be in, steering on the implementation of the law. But insofar as what we are doing as Access to Information Office, we did participate in the process of the coming into being of the Act. We also did participate during the drafting of the regulation, and we are hoping that as soon as the process of bringing on board the commissioner is done, we will call on her or him and work together to review, as we plentifully said, certain sections of the law under the access to information and under the data protection, which may be conflicting or which may work together. That is the position right now.
Thank you very much. Advocate Tlakula, that question was meant for you, but okay. Thank you very much, Commissioner Lucy, for also enlightening us on the current situation in Kenya. So to Advocate Tlakula, my question is on the Protection of Personal Information Act, that now we have a commencement date, and I was asking what then that means for us as members of the public, and what that means for the information regulator, and whether there is need for a review of the law, or it's still fit for purpose.
Thank you very much for those questions, and good morning to everybody. Just to start by saying that the information regulator was established in 2016 December. That's when the 5 members were appointed. The regulator consists of the chairperson and 4 members. 2 members are part-time, 2 members are full-time. And the regulator has a dual mandate, which is the protection of personal information, in other countries known as data protection. And also it is responsible for the promotion of access to information. The regulator is independent, is not accountable to the executive, but it's accountable to the National Assembly. When the Act was adopted in 2013, only certain sections thereof were brought into effect, and these are particularly sections dealing with the establishment of the information regulator. And then yesterday, the president announced in the media that he has now signed a proclamation to bring into effect not all the sections, all sections except 2 of the Protection of Personal Information Act into operation, and the commencement date is the 1st of July, 2020. He has postponed the coming into effect of 2 sections. One section which deals with amendment of laws and repeal of some laws, which have to be brought in line with the Protection of Personal Information Act, and particularly with the promotion of access to information. He has also postponed the coming into effect of the transfer of the Promotion of Access to Information Act from the South African Human Rights Commission, which is currently administering that act, to the information regulator, because a lot of work has to be done before the South African Human Rights Commission can transfer that function to the information regulator. So those 2 sections, 110 and 114.4 of the Protection of Personal Information Act, will come into operation on the 30th of June 2021. What has to happen now post-commencement? The Protection of Personal Information Act, in one of its sections, in section 114, provides that public and private bodies will have up to a period of 1 year from the commencement date to bring to conform to the Act, which means that there's a 1-year grace period within which private and public bodies must ensure that they comply with the Act. We have been engaging a lot of stakeholders on the Act. We'll continue to do that. We'll continue to provide training so that private and public bodies can put compliance processes into place. Is the law still fit for purpose, particularly taking into consideration that it was adopted pre the GDPR? I don't think, Hlengiwe, we can rush into amending our Act because it has just come into operation. I think we need to test its efficacy. We have to start implementing it fully for us to see whether there are any gaps in the law. But as it is, I think it is still fit for purpose. There might be a need later to adjust a few sections, but in large measure, it does compare favorably with the GDPR. But we all the time stress that the GDPR is not our standard, it's the European standard. We have to ensure that Africa adopts its own standard. That is why we are keen to see the convention that you have mentioned coming into effect. What should the public do in anticipation for the implementation of the Act? I think we have a big task as the regulator to educate the public on the Act, because there is a perception out there that the Act applies to big corporations and doesn't affect ordinary people, that the Act is really an ICT matter. The Act is a human rights, protection of personal information is a human rights issue. And we have to depart from that premise to say that protection of personal information affects two rights in particular directly, the right to privacy and the right to dignity. So we should have a human rights approach to that. And ordinary people also are victims of abuse of their personal information. And in the South African context, you would know that people here receive, poor people receive social grants in the form of old age grants, in the form of disability grants and child grants, which are social benefits. What happened in a few years ago, a company that was administering these grants gave the personal information of the grant beneficiaries to their subsidiaries. And these subsidiaries then use this personal information to market and sell goods and services to these poor people. In some instances, a situation arose where the poor people, without their informed consent, consented to them being sold funeral policies, being sold data for airtime. And by the time they received their social grants, there were lots of deductions that were made from their very little social grants because their personal information was used for the purpose for which they did not give the personal information. They gave the personal information for the purpose of receiving social grants, but the personal information was then abused for another purpose. So education is key, and we have to ensure that we roll out in consultation and in conjunction with civil society, a big education campaign. Let me stop here. Thank you very much.
Thank you very much, ma'am, for at least giving us an indication of where South Africa stands with regards to the framework that we have at the moment, and also letting us know how ordinary people are affected, and the problem of data exploitation in Africa. This is not only a problem in South Africa, but it's a problem that is experienced across the continent, and we are seeing data breaches happening, hence the need for this protection of personal information to be taken seriously. I just want to remind our participants to make use of the chat section, ask your questions and comment on the chat section. We want to hear your views about the subject of the day. Thank you very much. So to Prof Mamadou, Senegal is one of those countries that was one of the first countries on the continent to have a data protection law, and that was in 2008. And please take us through the journey regarding implementation. What has it been like in implementing this law? And what are those areas that you can point out as the milestones, things that you achieved during the process, and what have been the challenges during that process of implementation? It's been 12 years now since that law was adopted. And also Senegal was one of those first countries again to ratify the AU. It's one of the few countries that have ratified the AU Convention on cybersecurity and protection of personal information. And now I understand that Senegal is in the process of reviewing this law that we are talking about, the data protection law. So my question is, what has necessitated that review, and what are the changes that are envisaged? Prof.
Merci. Donc, cette loi, la réflexion sur la société de l'information au Sénégal a commencé vers les années 2003, après le premier sommet mondial sur la société de l'information de Genève. Et cette réflexion aussi s'est prolongée après le sommet de Tunis en 2005. Ce qui fait qu'entre 2003 jusqu'à 2008, l'année de l'adoption de la loi, le Sénégal a beaucoup réfléchi sur un modèle de protection de la vie privée et sur un modèle de protection des données à caractère personnel. En 2008, la loi paraissait nouvelle et prenait en compte l'état de la question en 2008, avec la situation de la technologie, l'évolution des droits humains et surtout des droits numériques. Je dirais que c'était une phase d'ancrage ou d'apprentissage de la protection des droits numériques, de la liberté d'expression dans le cyberespace. Ce qui fait que cette loi a fait son chemin entre 2008 et 2020, raison pour laquelle cette loi a été ou bien est en train d'être modifiée. Quels ont été les principaux défis? Il faut savoir que cette loi cherchait à donner au Sénégal les ressources d'entrer de manière durable dans la société de l'information, qui est une société internationale, qui est globalisée, et c'est une société qui est décentralisée, où les États doivent apprendre à composer avec d'autres types d'acteurs, le secteur privé, les associations et la communauté des internautes. C'est une nouvelle approche qui est très différente, fondamentalement différente, de l'approche qui consistait à simplement envisager la régulation du côté de l'État. On s'est rendu compte avec la pratique que cette approche devait suivre l'évolution de la technologie, mais devait aussi prendre en compte des phénomènes nouveaux qui apparaissaient au grand jour. Je donne l'exemple des réseaux sociaux, je donne l'exemple des blogs, je donne l'exemple de l'explosion de la presse en ligne. C'était des réalités qui, en 2008, n'étaient pas très connues, peu connues, voire qui n'existaient pas. Donc, entre 2008 et aujourd'hui, de nouvelles réalités sont venues, de nouveaux défis sont venus s'imposer à la société de manière globale, au-delà du Sénégal, à toutes les sociétés africaines. Donc, il a fallu repenser notre loi. Mais il y a eu quand même des acquis avant de pouvoir repenser notre loi. Parce que entre 2008 et 2014, quand on a vraiment commencé à faire fonctionner la commission, parce que la commission existait dès 2008, mais la commission de protection des données personnelles a été réellement établie qu'en 2014. Elle a commencé à fonctionner en 2014. De 2014 à 2020, il s'agissait de faire connaître cette loi aux populations, aux entreprises privées et aux autorités publiques. Donc, c'était une phase de sensibilisation et ensuite une phase d'élaboration des outils de protection, comme les formalités préalables, comme des outils d'accompagnement à la conformité, donc tout ce qui est certification, labellisation. On était dans une phase d'implémentation de la culture de protection des données à caractère personnel au Sénégal. Maintenant, cette phase a connu un peu de succès parce que depuis la création de la CDP jusqu'à présent, nous avons enregistré quelques 3000 dossiers, beaucoup de plaintes qui portent sur des usurpations d'identité, sur des chantages, sur la pédopornographie, sur la diffamation, la divulgation de contenus illicites, etc. Cela nous a permis de savoir quels étaient les droits qui étaient réellement en danger par rapport à la vie privée et aux données à caractère personnel. Cela nous a aussi permis de dialoguer avec les entreprises et de voir quels étaient les besoins des entreprises en termes de traitement de données. Parce qu'un régulateur, c'est un arbitre. Nous ne pouvons pas empêcher le progrès technologique. Nous ne pouvons pas empêcher aussi l'usage de la technologie pour répondre aux défis de la société, les défis économiques, les défis sociétaux, etc. Donc, ce qui a fait que, dorénavant, l'autorité comprend mieux quels sont les besoins des secteurs privés, quels sont les besoins de la population. C'est la raison pour laquelle, ou l'une des raisons pour lesquelles, la loi a été modifiée. Donc, cette proposition de loi n'a pas encore été adoptée par le Parlement, mais cette proposition de loi vise à élever le niveau de protection offert par le Sénégal et à harmoniser les pratiques sénégalaises avec les législations au niveau international. Peut-être que, contrairement à d'autres pays africains, le Sénégal est membre de la Convention 108 du Conseil de l'Europe, ce qui nous oblige aussi à intégrer ces éléments dans notre dispositif. Le Sénégal aussi a ratifié la Convention de Budapest en matière de lutte contre la cybercriminalité, ce qui a fait que nous avons changé le code pénal pour mieux protéger les données à caractère personnel. Et comme vous l'avez si bien souligné, le Sénégal a ratifié la Convention de Malabo de 2014. Heureusement qu'à ce jour, la Convention continue d'être ratifiée. Le Zimbabwe l'a ratifiée très récemment, au mois de juin, ce qui fait qu'environ 7 pays ont ratifié la Convention de Malabo sur les 15 signatures nécessaires pour l'entrée en vigueur de cet instrument important, qui, du reste, appelle à être révisé et à être harmonisé par rapport aux différents instruments régionaux, comme ce qui existe en Afrique australe, en Afrique de l'Est, en Afrique du Nord, etc. Donc, il y a déjà des instruments régionaux qui doivent être adaptés aussi à la situation nouvelle. Donc, en termes d'enjeux, en termes de défis, aujourd'hui, la tendance est à la responsabilisation des acteurs. Ce n'est plus un régulateur directif qui fixe le cadre et que les responsables de traitement viennent se conformer. Non, le régulateur fait confiance aux responsables de traitement, au secteur privé, au secteur associatif, et derrière, le régulateur élabore des outils qui lui permettent de mieux contrôler l'usage que l'on fait des données à caractère personnel. Par exemple, avec le Privacy Assessment, qui nous permet d'avoir une étude d'impact avec les outils de conformité comme la labellisation, comme l'homologation des politiques de protection. Donc, en termes de défis, l'idée, c'est de pouvoir aller de l'avant en harmonisant les politiques africaines afin que l'espace de libre circulation des données créé par la Convention de Malabo, par l'instrument de la CEDEAO, puisse se faire dans un sentiment de confiance mutuelle, dans un sentiment, dans un cadre réciproque où les acteurs ont une confiance mutuelle et où le niveau de protection des droits individuels est le même, en fait, dans tous les pays. Qu'il n'y ait pas de paradis où certains délinquants pourront s'installer et exploiter librement les données à caractère personnel. Voilà un peu le parcours et le paysage législatif actuellement. Et les défis qui s'annoncent pour le Sénégal, c'est de continuer au niveau national à promouvoir la protection des données à caractère personnel et au niveau africain de matérialiser les missions du réseau africain de protection des données à caractère personnel, c'est-à-dire avoir des législations harmonisées, des bonnes pratiques qui sont partagées et une meilleure conscientisation des populations sur l'importance de la protection de leur vie privée. Pour ne pas trop monopoliser la parole, je vous remercie et je vous rends la parole.
Thank you very much for the Senegal perspective. I just want to give an opportunity to Mr. Omar from Morocco, so that at least we get a perspective of we get a North African perspective. Mr. Omar from Morocco, tell us about the framework in Morocco, the data protection implementation and the challenges, just briefly.
Bonjour, je vous remercie pour cette occasion de présenter la situation au Maroc. Je salue mes homologues et mes collègues en Afrique, et les différents experts et participants. Au Maroc, nous avons maintenant une dizaine d'années en termes de retour d'expérience par rapport à la loi. La loi 0908, la commission, la CNDP, a été installée en août 2010. Elle a fait 2 mandats. Elle termine le 2e mandat cet été. Et nous avons observé un certain nombre de choses. Tout d'abord, la situation n'est pas facile parce que nous sommes arrivés sur un droit et on peut dire que ce droit n'est pas toujours compris par les uns et les autres. Après, il a fallu, et on continue, ce n'est pas encore terminé, bien expliquer que ce n'est pas une question de technique, mais c'est une question liée aux droits de l'homme et c'est une question liée aux droits humains, au respect de l'autre et au respect de la vie privée. Nous avons l'article 24 de la Constitution qui garantit le respect de la vie privée et nous avons l'article 27 de la Constitution qui garantit le droit d'accès à l'information. En fait, le président de l'autorité de protection des données, la CNDP, préside également une autre commission qui est la commission du droit d'accès à l'information. Et donc, beaucoup de questions se posent et évidemment, aucune loi n'est idéale et n'est aboutie. Et nous sommes en train de travailler pour refondre la loi et pour pouvoir intégrer notre recours d'expérience, intégrer de 10 ans sur la partie protection des données et intégrer un certain nombre de choses. Alors, qu'est-ce qu'on cherche à faire? Ce qu'on cherche à faire, c'est travailler au niveau pratique et culture. On est conscient que la loi en tant que telle ne va représenter, enfin, pour rester dans les ratios connus, que 10 à 20% de la réalité des choses. Mais il faut qu'on arrive à faire insérer au niveau de la pratique de tous les jours, au niveau de l'intervention de chacun, au niveau des responsables de traitement, au niveau des citoyens, pour qu'ils puissent connaître leurs droits et en user et pouvoir le faire facilement. On doit travailler à ce niveau-là. Et donc, en fait, on est en train de défendre la notion de confiance. Vous me dites si je suis trop long pour que je résume. Donc, on est en train de travailler sur la notion de confiance, confiance numérique, mais pas que numérique, puisque la protection des données ne concerne pas que les systèmes numériques, elle concerne toutes les pratiques, que ce soit en papier ou autre. Et en même temps, faire en sorte que les entités les plus représentatives de l'État puissent également donner l'exemple et rentrer leur traitement dans les déclarations nécessaires. Et donc, nous travaillons à ce niveau-là, c'est pas toujours facile. Parfois, nous sommes amenés à le dire et on le dira chaque fois que nécessaire, parce qu'on pense que la réussite de ce genre de loi est bâtie sur la confiance. Et la confiance nécessite une transparence dans la façon de s'exprimer, une transparence dans la façon d'expliquer les choses. Et quand c'est blanc, il faut dire que c'est blanc, et quand c'est noir, il faut dire que c'est noir.
Thank you very much. We are racing against time. Thank you for at least we have managed to hear the perspective from Southern Africa, from Kenya, East Africa, from Senegal, West Africa, and Morocco. So now we're going to move on to the COVID-19 specific issues on privacy and data protection. On this aspect, you realize that governments and health authorities are looking for data which can inform their decisions. So a lot of data is being collected, is being stored, a lot of data is being shared. And the question is, in as much as the important thing is protection of public health, what are the implications on privacy and on individual privacy? What are the implications on data protection? So all these issues around contact tracing and testing. If you look at South Africa as of yesterday, more than 1 million tests have been conducted, and you can imagine that if 101,000 people have tested COVID positive, the amount of contact tracing that then follows, and that also comes with collection of information. And then we are moving on to reopening plans where economies are reopening, schools are opening, and there's going to be a lot of monitoring, a lot of testing, temperature checks. So there are issues around who is conducting the tests, how is the information being stored, is there any particular guidance that is being provided from the government level? Are there any rules and regulations that have been put in place for sharing data? Do we have any stringent measures for making sure that the data is secure? Confidentiality policies are they in place? Where does COVID-19 find ourselves? And looking at the data protection laws that we have at the moment, the existing ones, the question then is, to what extent are these laws informing the responses to COVID-19, and how adequate are they in addressing issues that we are currently faced with? We'll start off with Madam Lucy from the Kenyan perspective. How is it like in Kenya, privacy, data protection, the laws in place? Please take us through the Kenyan experience.
Good. Sorry, my mic had gone off. Thank you. In Kenya, we do have access to information law and data protection law. I will talk more on access to information. On access to information, the Act did commence in 2016, and the Commission on Administrative Justice has been implementing it. As soon as COVID-19 pandemic took place, the Commission had to adhere to the Ministry of Health guidelines on all the issues related to working, and we had no choice but to kind of scale down the activities, including insisting that no members of public will be visiting our offices. So what we did, we set out certain guidelines to the members of the public on a way of how they should request for information, and we told them to use online platforms, and we also requested our staff to work on rotational basis and for few hours. During the COVID-19 time, we have received about 13 reviews insofar as ATI is concerned. This ranges from requests for information by those persons who were quarantined. They felt that they were not getting the necessary information insofar as their health, their stay, and the contact tracing, like you stated, it was concerned. What we did alliance with the Ministry of Health through lighting, and some of those issues were addressed within the ministry. Others are still pending, and we do hope that they will be solved soon. Apart from that, as a commission, we have been participating online with other regulators insofar as COVID-19 is concerned. And we did participate with the journalists, whereby we handed over a handbook on access to information on how they will request information, how they will receive information, and if they do not receive information, they could come to us as a commission. And we have been working very well with the media. Further, as a commission, we have worked with the public civil societies, whereby we participated in open government partnership through holding this kind of platform like this one and discussing what we should put in place during COVID. We also have worked with the Conference of Information Commissioners, where we did deliberate on a joint statement regarding COVID-19 pandemic, and we participated fully and agreed on the statement, which was to be put in our website. Insofar as the issues or the requests are concerned, we noticed that how funds are being used by government has been a serious concern in our situation, and many requesters were feeling that they were not getting the right information related to the use of funds. They were also concerned that they were not getting enough information related to how to take care of themselves. And this one, we thought we should hold a meeting with the Ministry of Information. We are waiting for a chance to talk to them. As a commission, we have been issuing statements that we are committed to help Kenyans get the relevant information, and we are truly thankful to the media who have been there for us, giving all the information as and when they receive through the ministry. And we also know that Kenyans have been participating in social media, requesting for information, and when they do not get it, they come to us. And insofar as the Act is concerned, we feel that there is more to be done insofar as the protection or certain information is protected. And that certain information which is protected perhaps will require to be looked at, and we amend the Act accordingly. Further, we do know that health is a right issue, and it is not really elaborated in our Act, and we feel that certain amendments must be done to our law related to health and any other pandemic that may happen. Thank you very much.
Thank you very much. You have highlighted on an equally important issue, which is access to information in this COVID context. Now we're gonna move on to Advocate Tlakula. The situation in South Africa as far as privacy and data protection is concerned in this COVID-19 context, what has been the role of the information regulator and what are the privacy issues that arise in COVID-19, at least in the context of South Africa? And also, maybe if you can also address us on issues around the reopening plans, and now that we schools have started opening, the privacy of children, data protection, has there been enough awareness with regards these issues of data protection in South Africa?
Thank you very much. In the South African context, immediately after the government adopted or made regulations on tracing and tracking, the information regulator then issued a guidance note on how to protect personal information of data subjects in the process of managing the pandemic. And the privacy issues really that arise for us is really that a lot of personal information, as you know, has been collected by the National Department of Health through the Director General, who is the custodian of the National Database on Tracing. And that database contains the names, the surnames, cell phone numbers, and residential addresses of all the people that have been tested and their contacts, and also the results of their tests. And this database is made up of information received from the electronic communication service providers, from the National Institute for Communicable Disease, and also from any institution that holds the national address database. So here is this database held by the DG of National Health. The question is, what security measures have been put in place to ensure the integrity and the confidentiality of that information? Do we have adequate technical and organizational measures in place to ensure that there is no unauthorized access to that information? And this becomes important if one takes into consideration the high number of data breaches that we are experiencing in our country. Between the beginning of the year and now, we have, as the regulator, received 7 notifications of major data breaches. And the last one is the one that occurred just this month, where the database of the one of the health service providers, the Live Health Group, was breached. This is a hospital group. So security remains a big concern, because cybersecurity is well and alive. We're all working remotely, and I'm sure the cyber criminals are looking out there, looking who they can breach. The second issue is what will happen after the end of the national state of disaster to that information. Although the regulations provide for the de-identification or destruction of the information, we have to make sure that that happens. It is unfortunate that when the government came up with this regulation on tracing, contact tracing, they did not consult us as the regulator. Maybe they didn't, because they felt that at that time some sections of our act were not effective. What then happened was that the Minister of Justice and Correctional Services then went to designate a retired judge as the COVID designated judge, as she is called in the regulations. And what are her responsibilities? The responsibilities are, one, the DG of Health must submit to her every 2 weeks the personal information of people that they have the people that they have traced for COVID. And all that she can do is to make recommendation to the executive on how the regulations can be amended to ensure the protection of privacy and personal information of the persons infected or by COVID or their contacts. So let me leave it here, but that's really, and the question that you asked about schools, I think of concern to us, and this is a matter that we will follow up. If testing is going to be done in schools, the issues of consent, because we are talking about processing of personal information, special personal information of children, which has to be dealt with in a specific way in our legislation. So issues of consent come into being, and also the confidentiality and security of that information. But I have to state as my last point that the regulations that were the chasing regulations, they make it an offense for anyone to breach confidentiality and to use the personal information for the purpose for which it was not collected. Let me stop here. Thank you.
Thank you very much. At least that's the South African response and the issues arising on privacy South Africa. So in Senegal also, Prof, kindly address us on the measures that have been taken to ensure that people's personal data is protected, and also maybe if you can enlighten us on the data breaches that you have experienced and how these have been dealt with. And also, if you're looking at the Senegalese situation, would you say that the public is justified in expressing fear that this data that is being collected might be abused? And what changes can we envisage going forward in the legal framework after having gone through this phase of COVID-19? And are there any legal issues that arise when we are looking at since the beginning of this pandemic, and what changes, like I've said, can we expect? And if you are looking at the current law as it exists in Senegal, the data protection law, is it enough? Is it adequate to deal with the privacy issues and data protection issues that arise?
Oui, merci. Donc, je dirais que la situation est un peu semblable à celle décrite en Afrique du Sud. Donc, les autorités publiques ont dû faire face à une urgence avec la pandémie de la COVID-19 et des mesures devaient être prises. Parmi les stratégies de gestion de la maladie, il y a évidemment le volet sanitaire, mais la technologie aussi s'est imposée comme une réponse très, très rapidement, avec le besoin de tracer des cas contacts et le besoin de tracer aussi les personnes malades pour éviter la propagation du virus. Je dois dire qu'il y a eu au début un certain malaise dans la gestion, pour l'autorité en tout cas, dans la gestion de la protection des données à caractère personnel. Il y a les réponses de l'État, ensuite il y a les réponses citoyennes, c'est-à-dire des initiatives privées qui ont aussi voulu offrir de contributions. L'État s'est rapproché du régulateur. Donc, un peu contrairement à ce qui s'est passé en Afrique du Sud, où pour des questions juridiques, peut-être les autorités publiques n'ont pas consulté les régulateurs. Au Sénégal, les autorités publiques et à ce niveau ont été créés par le ministère des Technologies, et dans ce comité, l'autorité de régulation est membre. Donc l'autorité de régulation aide les pouvoirs publics à prendre en compte dès la conception des applications, dès la conception des plateformes, la protection de la vie privée et des données à caractère personnel. Ce qui a abouti à l'application d'un communiqué par l'autorité de régulation, le régulateur, appelle à l'État quelles sont les législations dans un cadre de pandémie, d'urgence sanitaire, et dans un cadre où les réponses doivent être très, très réactives et efficaces. Ce qui fait que les recommandations principales ont consisté à dire que toutes les données de santé collectées doivent être hébergées au Sénégal, toutes les données de santé, afin d'avoir un contrôle sur l'utilisation et la réutilisation qui serait faite de ces données, et afin de nous assurer du respect des finalités. Le problème le plus important en matière de données à caractère personnel auquel le Sénégal a dû faire face, c'est le problème de l'utilisation des données de localisation, de géolocalisation et du recours aux opérateurs de télécom. Parce que les opérateurs de télécom ont refusé de donner des informations eu égard à la protection des données à caractère personnel et de la vie privée, qui est prévue non seulement par notre loi sur les données personnelles, mais aussi par le Code des télécommunications, et pour ne pas faire face à des actions en justice plus tard. Donc, les opérateurs de télécommunications ont exigé à ce qu'on respecte la loi. La loi demande qu'il y ait une base juridique, c'est-à-dire un texte réglementaire pris par l'État ou par le Parlement qui puisse autoriser le traitement des données de télécommunication, des données de géolocalisation. Ce qui a fait que la plupart des applications se sont tournées vers d'autres solutions comme l'utilisation du Bluetooth afin de contourner le refus de collaboration directe des opérateurs de télécommunications. Donc, des solutions d'équilibre sont en train d'être recherchées pour qu'un régime dérogatoire soit reconnu afin que ces données aident l'État à avoir toutes les informations nécessaires pour faire face aux problèmes. Par ailleurs, des initiatives privées, des particuliers, des entreprises ont déposé des demandes d'autorisation pour des applications qui visent à donner des informations, des applications d'alerte ou des applications de suivi et de traçage des cas contacts. L'autorité a reçu ces demandes d'autorisation et a étudié la meilleure manière de donner une autorisation. Et dans tous les cas, ce qu'on rappelle, c'est que la vie privée, l'intérêt de l'être humain doit être au centre de la réponse technologique. Il ne faut jamais perdre de vue qu'il s'agit d'un être humain, de sa vie privée, et quand bien même il y aurait une mesure d'urgence, un intérêt général à préserver, la santé publique, l'être humain doit rester la finalité ultime de la loi sur la protection des données à caractère personnel. Ce que nous a vraiment enseigné cette pandémie, c'est que nous nous étions jamais confrontés à une situation d'urgence qui exigeait la collecte et l'utilisation massive de données à caractère personnel de la population, parce que là, on parle de centaines de milliers de personnes, l'utilisation de données à caractère personnel avec des technologies parfois très intrusives. Qu'il s'agit de big data, qu'il s'agit d'intelligence artificielle, chacun y allait de sa solution. L'autre élément, c'était les mesures qui sont incidentes, par exemple en milieu d'entreprise. Pour prévenir la propagation du maladie, certaines entreprises ont mis en place des systèmes de collecte de la température, des systèmes d'enquête sur l'état de santé des salariés ou des mesures aménagées, des mesures d'accès à l'entreprise pour protéger les salariés. Ces éléments-là n'existaient pas avant. Donc, voilà un peu, bon, le temps joue contre nous, je ne vais pas trop prolonger le débat, mais voilà un peu en termes d'enseignement. Ce que nous avons appris, c'est faire face à l'urgence avec la
Okay, thank you very much for the giving us the Senegalese experience on COVID-19. I'm going to allow 3 participants to raise questions. Just 3, use the reactions function to raise your hand. Just 3, and make your interventions like 1 minute or less. Tiruna, please assist. I'm not hosting, so I can't see who is raising their hand.
There currently aren't any hands raised.
Okay, if there are no hands raised, you can be preparing your questions. But my next question to Advocate Tlakula is on the issue of de-identification of data. I think it will be common practice that eventually we'll have all this data that is being collected, de-identified, such that it cannot be traced to a particular or specific individual. But we know that with these technologies that we are adopting and embracing, there will be that possibility of re-identifying. Of re-identification. So the question is, what are there any, have you as the information regulator, the Office of the Information Regulator, engaged on those issues of making sure that de-identified data is protected?
Yes, what we did, we wrote a letter to the Director General of the National Department of Health to actually find out what processes is he going to put in place after the end of the state of disaster to de-identify the information. Unfortunately, the DG started, took up employment on the 1st of June. He is new and he did respond that he has hit the ground running. As you know, there are lots of issues that the department is dealing with. but we will follow up with him to ensure, particularly towards the end of the national disaster period. We have also written to Judge O'Regan because we want to meet with her so that we can share notes and collaborate on how she, as the designated judge, and us can strengthen the protection of the right to privacy and personal information of those infected and tested for COVID-19. Thank you.
Thank you very much, ma'am, on that. To Professor Mamadou, let's talk about the issue of identifying people that have passed away because of COVID-19, those that have fallen ill, or those that have that are vulnerable. What ethical or legal protection measures should be accorded in a pandemic such as this one, which poses serious threats globally?
Votre question est très intéressante et très importante parce qu'au Sénégal, nous faisons face à une vague de stigmatisation des personnes qui sont décédées, des personnes qui sont mortes. Peut-être que vous avez suivi l'actualité et certaines populations ont voulu s'opposer à l'enterrement des victimes de COVID-19. Donc, c'est aller un peu trop loin dans la stigmatisation et ça pose la question justement de la publication des noms ou des statistiques sur les personnes qui sont décédées et de leur localité d'origine. Nous pensons qu'à l'avenir, l'État doit prendre toutes les mesures afin de préserver, afin de mieux communiquer et que les populations ne sentent pas comme une sorte d'exclusion ou de stigmatisation le fait d'être atteint de la COVID-19. Donc, pour nous, tout est question de comment communiquer. Parce qu'on peut donner des statistiques, on peut donner des noms si la situation l'exige, mais c'est la manière de communiquer qui doit être la bonne ou la meilleure. Là, nous pensons qu'il y a un sérieux problème de protection de ces personnes afin que leur dignité soit respectée après le décès. Car l'enterrement de la personne décédée et la préservation de sa mémoire font partie des éléments qui composent la dignité humaine et c'est des droits fondamentaux. Donc, c'est un peu regrettable, mais voilà, nous allons travailler avec le ministère de la Santé dans ce cas et voir comment gérer les pertes humaines en matière de crise sanitaire à l'avenir.
Thank you very much. We have a question for Senegal, and the question is, what measures are being put in place to protect the independence of the Data Protection Commission in Senegal, especially since the Data Protection Act's draft indicates that the Commission is accountable to the President rather than Parliament? Did you get that question, Prof?
Oui, j'ai bien compris la question. En fait, dans le projet de loi, la reddition des comptes, le rapport va s'adresser à la fois au président et au Parlement. Il faut savoir qu'au Sénégal, c'est une pratique dans l'administration que les autorités indépendantes déposent un rapport annuel devant le président de la République, qu'ils adressent le rapport annuel au président de la République. Mais la loi précise clairement que la Commission ne reçoit aucune instruction d'aucune autorité. Et ça, c'est le siège de l'indépendance de la Commission. Donc, les membres de la Commission ne peuvent pas être révoqués durant leur mandat, sauf pour les fautes très graves qui peuvent pour la démission ou le décès. Mais mieux encore, la Commission ne reçoit aucune instruction d'aucune autorité. Et c'est ça qui renforce l'autonomie et l'indépendance de la Commission. Et je suis bien placé pour vous dire que de ce point de vue, la Commission est très indépendante parce que nous sommes très souvent en conflit avec les autorités publiques sur des questions de protection des données à caractère personnel. Et les autorités publiques nous écoutent et appliquent nos recommandations ou nos solutions. C'est l'exemple des élections, c'est l'exemple du ministère des Transports récemment avec le déconfinement. C'est l'exemple du ministère de la Santé. Je peux continuer à donner d'autres exemples, mais dans la pratique, la commission est très indépendante. Même si aucune situation n'est parfaite par ailleurs. Voilà, je ne sais pas si j'ai bien répondu à sa question. C'est de la manière dont j'ai compris sa question.
Okay. Thank you very much for your response, Prof. We have a question here that I think Commissioner Lucy can respond to. It says, how are the issues of privacy specific to marginalized groups, in particular women, addressed or thought of in data protection laws? How are issues of privacy specific to marginalized groups addressed, in particular the issue of women? Commissioner Lucy, do you think you can respond to that one?
Yes, I can. Under our law, we do have a commission called the Commission on Gender, and they are supposed to work hand in hand with all other departments dealing with marginalized. And during this time of pandemic, we do know that there has been a lot of issues related to privacy and marginalized communities and how they have been treated during contact tracing, during providing of information, during barrier, and especially during barrier. So what has been happening is that our commission, that is on gender, has been working with the Ministry of Health, and they did come up with understanding and guidelines on how to treat the marginalized groups, especially when it comes to women. Also, we do know that during barrier, there has been a lot of issues on how we'll follow the ministry guideline and at the same time deal with our cultural issues. And the ministry had to liaise with the community at the ground, and they came up with guidelines which were almost acceptable by the marginalized community. When it came to women, we do know that the pandemic has truly affected them, but our government came up with some incentives, money to assist the marginalized group to deal with pandemic. Thank you.
Thank you very much. Mr. Omar from Morocco, your hand was raised. Please proceed with your question. Briefly.
Merci. Merci, oui, très vite. Ma question est la suivante. C'est qu'on a tous rencontré à peu près les mêmes problèmes au niveau pendant la crise du Covid-19. Et nous particulièrement, mais je pense que tout le monde a rencontré la même chose, on a plusieurs projets technologiques qui se mettent en accélération en utilisant l'explication du Covid-19, comme quoi il faut faire vite, il aurait fallu faire ça très vite, etc. Et ça introduit technologiquement, mais en termes d'usage, des utilisations qui ne sont pas très respectueuses de la protection des données et de la vie privée. Nous, au Maroc, l'autorité de protection est réticente quant à l'utilisation d'un identifiant unique permettant de tout tracer, tout voir, etc. Je voudrais savoir, au niveau des collègues en Afrique, comment ils perçoivent ça et est-ce qu'ils pensent qu'il est possible de laisser se mettre en place des systèmes à base d'identifiants uniques publics pouvant mettre en danger un certain nombre de choses. Merci.
Thank you very much. Advocate Tlakula, are you better placed to respond to that question?
I'm sorry, I've been responding to chats online, so I didn't hear the question. I'm sorry. Maybe one of my colleagues can, maybe Senegal can take it, sorry.
Senegal, Prof.
Sur cette question, je suis du même avis que le président Segrouchny. Donc, la commission mène une réflexion sur la possibilité de permettre l'usage massif d'un identifiant unique afin de pouvoir tracer et collecter les données. Et jusqu'à présent, nous sommes assez réticents. Nous sommes pour l'usage d'identifiants dynamiques et temporaires afin que ces informations puissent être effacées à l'expiration de la finalité. Mais autoriser un identifiant unique qui serait une porte d'entrée pour toute forme de traitement, c'est un élément qui est très, très dangereux pour les libertés individuelles et les droits fondamentaux. La réflexion est en cours, mais mon avis personnel rejoint l'avis du président Sekou. Merci.
Thank you very much. As we close, we are going to address these two questions. The first one, I will allow all of you to respond to the questions. The first one says, it's directed to Advocate Tlakula, but others can also respond. That Advocate Tlakula mentioned that Africa needs to adopt its own data protection standards as opposed to copying the European standards. Now talking about intergovernmental and regional cooperation in Africa, e.g. regional frameworks, such as the SADC model law that are non-binding, do you think this could be one reason countries are reluctant to pass personal data protection legislations at national level? What are we where are we missing it in Africa? We can start with you, Advocate.
I think the whole issue of data protection is quite new in most countries on the continent, and we are overwhelmed by a number of laws and institutions that have to be established. But the reality is that in this era of the fourth industrial revolution and encouragement to all go digital, establishment of the digital economy, the right to privacy is the current right, it's the currency. So I think we all have to step up because it's a new human rights, whether we like human rights, whether we like it or not. The African Union is not going to help us because, as the question correctly points out, it is an intergovernmental organization. It will just adopt a convention, which will not be binding in nature, but that convention will, at least if it comes into effect, sort of encourage countries to adopt data protection laws to give effect to the convention. I think at this point in time, that's where the national, the network of African data protection authorities becomes important. And it has to ensure that it encourages countries to adopt laws, and the network has to work hand in hand with the African Commission on Human and People's Rights, because during my tenure at the Commission, I found that the Commission can play quite a critical role in pushing for the ratification of our instruments. So that's my response to the question. Thank you.
Okay, thank you very much. To Commissioner Lucy, kindly respond to this question. It is saying that what measures are the different data protection commissioners taking to make sure that the measures taken for COVID-19 are not, do not become the new normal, especially for the representative from, well, the person was expecting the response to come from South Africa and Senegal, but I think Kenya as well. These are issues that affect Kenya. We can start with you, Madam Lucy, and then we can move to Prof. What measures are the data protection commissioners taking to make sure that what is happening now with regards to data protection and privacy does not become the new normal?
Thank you. What I believe we should do as Kenya is to ensure that the new normal is not put in our laws. It is not adopted as the norms, and it should be taken as only guidelines for this particular time of COVID-19. But as soon as we get out of here, we go back to our laws and implement our laws as they should be. What has happened so far, we have not passed any of these guidelines which are restrictive during COVID-19 into our law. We are issuing them as guidelines affecting us at this particular time. There are those which perhaps will follow into a law or into a regulation, and those are the ones which we believe we must live with them. So the new normal must be looked at within the context of which we are operating. That's my comment.
Thank you, Prof. Same question.
Non, nous pensons la même chose que le Kenya. Donc, puisque c'est une exception, en tout cas au Sénégal, dans la loi, la situation de la COVID-19 a été gérée sous le régime de l'exception en raison d'un intérêt public, c'est-à-dire la gestion de la crise sanitaire. Une exception doit rester une exception et la règle donc être préservée. Il ne faut pas changer l'esprit de la loi parce qu'une crise est là. Donc, comme en matière environnementale, après une crise écologique, il faut tout faire pour retourner à l'écosystème normal. Donc, nous pensons la même chose que le Kenya et l'Afrique du Sud. Merci.
Thank you very much. As we close, we'll allow our speakers to say their closing remarks. And in articulating your closing remarks, please I address issues such as the possibility of having privacy laws harmonized on the continent. To what extent can African privacy laws be harmonized? And post-COVID-19, what can we envisage going forward? Do you see a possibility of the strengthening of the right to privacy now that we have seen how this pandemic has indeed impacted on the right to privacy? Going forward, do we see any strengthening of these rights, and also anything that you want to say in closing? We can start with Madam Lucy, then Advocate Tlakula, then Prof.
Thank you. First and foremost, I wish to thank the organizers of this program. It's my first time to participate, and I felt that I learned a lot, and I wish to continue participating, not just me, but also our other sister commission, that is the Data Protection Commission. I want to state clearly that we need to harmonize our laws. We have realized that during this pandemic, we were truly connected. What was happening in Tanzania is what was happening in Kenya and in Uganda, and because of lack of the same rules, the same regulations, we hit certain barriers. So to address these barriers, it is important to have harmonized laws on data protection, on access to information, or good standard which can cut across the countries. And post-COVID-19, as an African country, I am of the opinion that the network should be strengthened. The network should also involve all countries in Africa. And we do know that if we network, we will be in a position to address any pandemic which may come in future. We also be able to strengthen our laws on data protection and access to information, or freedom of information. I look forward to the next meeting. Thank you very much.
Thank you, Advocate Tlakula.
Yeah, my closing remarks, I do agree with my sister from Kenya that there is a need to harmonize, at least to have a standard, particularly when it comes to the conditions for lawful processing of personal information. At least if we have standard conditions, we have to look at issues of trans-border information flows and also enforcement mechanisms, because there's no point in having a regulatory authorities which does not have effective enforcement mechanisms. I'm scared, actually, I have to say, because I think COVID has opened the floodgates for the violation of the right to privacy. I think all of us as civil society as regulatory authorities, we have to remain vigilant to ensure that going forward, our information, which is now floating everywhere, is not abused, and to ensure that that information was used for this purpose, which is an exceptional health problem that we all experienced. And like Senegal, this should be an exception and not a norm. But post-COVID, we have to be very vigilant and ensure that there's no abuse, further abuse of private information of people infected and those who were in contact with those infected by COVID. Thank you very much, and thanks a lot for inviting me. It was a pleasure to participate. Thank you.
Thank you, ma'am, for your interventions. Prof, your closing remarks.
C'est vraiment dommage. J'aurais bien aimé que les dames aient le dernier mot. Et au passage, je salue l'expertise féminine en Afrique. Donc, et je reste confiant sur la capacité de tout le monde à trouver des solutions idoines. Nous pensons aussi que les travaux de l'Union africaine actuellement doivent être encouragés par tous les pays, parce qu'avec la Commission de l'Union africaine, la révision de la Convention de Malabo est en marche et la plupart des pays africains prennent part à ces travaux. Et tout le reste, je tiens vraiment à saluer le Centre for Human Rights, je tiens à saluer aussi tous les participants, tous ceux qui ont laissé leur activité pour nous écouter, échanger avec nous et enrichir nos interventions. Voilà, donc pour les mots de la fin, je vous remercie vraiment et je le fais aussi au nom de la Commission de protection des données à caractère personnel, particulièrement la présidente empêchée qui m'a demandé de le représenter. Merci.
We have come to the end of today's discussion, but I'm sure now you have an understanding of where we stand as a continent, at least from the representatives that we had today. The situation as it pertains to South Africa, as it pertains to Kenya, to Morocco, Senegal, so and also what it means for the right to privacy and what the different regulators have put in place, or the different measures that have been put in place in different jurisdictions in response to COVID-19. And also what we've noted is the need to continuously strengthen work around the right to privacy, and also the issue of harmonization of laws also was mentioned. So this is a very important subject that as the Center for Human Rights will continuously engage. And on the 7th of November, 7th of July, we will have another webinar. We will have speakers from the academia, we'll have speakers from the civil society also tackling these issues. Today, we wanted to hear from the data protection authorities. So thank you very much for taking your time to be with us. I hope you participated in the poll. We value the information and the feedback. Thank you very much and have a good day. Goodbye.
Bye. Thank you.